This is another continued hearing in the matter of Colon Township versus Alfred E. Yoder and Joanne Yoder. There are two files, 25040CZ and 25533CZ. These are circuit court matters. I inherited this case earlier this year from Judge Stutzman when he disqualified himself, made a number of rulings, had a number of hearings. Keep hoping this matter will be over and completed. And the defendants have filed additional pleadings. I'm not sure I exactly understand everything. And then again, some pleadings were filed just the other night, January 21st, which was Wednesday before the pipes broke. So I had made my rulings. Mr. Thornton, on behalf of the township, submitted the orders for presentment. Defendants filed these additional pleadings, and here we are again. Mr. Thornton has filed a response pointing out the irregularities in the defendant's motion and pleadings, and he's asking for sanctions on behalf of the township for continuing to have to come back here regarding these motion hearings. So, Mr. and Mrs. Yoder, you're the motion filer here. What are you asking me to do?
Your Honor, we're here on our written motions challenging the accuracy of the proposed order and opposing sanctions.
All right, what's your challenge to the accuracy of the order?
It's very misleading. And it does not match the transcript, not even close.
What part of it don't you like?
Most of it.
Well, my reviewing of it is it was consistent with the orders I made here in the courtroom. They don't have to exactly track where it was said in the courtroom. You filed these pleadings, and as I've said repeatedly, someone's helping you, someone without a law license, but access to Chat GPT, other AI generated stuff. They're terrible. Their pleadings are terrible. They're leading you down the incorrect path. They're going to end up costing you lots of money, and they filed fraudulent or incorrect, at worst fraudulent, at best incorrect or lazy or incompetent pleadings on your behalf. They cited authority that doesn't exist. Anyway, and then they can't speak for you because they aren't lawyers. And I can't go back and redo the past. I told Ms. Wertelman this, I told others. If you had a competent lawyer at the start, we'd have been a lot better off than we are here.
What, Your Honor, what do we have missing?
All right, well, we'll get to that. All right, so you tell me you file these things, you object to everything in the order. You don't like anything that's in it. I need you to be a little more. Now, you do have these pleadings that you filed, which state these things. All right, well, all right, so you've got defendant's motion order to show cause in 2540 and 25433. And you've got a motion to strike proposed order of December 4th. Law requires that a written order match the oral ruling. Proposed order mischaracterized what the court actually did. The judge may not mock himself to avoid judicial duty. And then eventually you object to the entry of proposed order. So that's the first thing. You're objecting to the entry of the orders. Mr. Thornton, what's your response?
Your Honor, the court's rulings in the hearing held in both of these cases on December 3rd of 2025 were not extensive or complicated. The two proposed orders that I prepared at the court's request with regard to the denial of the Yoder's motions on December 3rd, 2025 are brief, accurately reflect the court's rulings on that date, and if the Yoders had competent counsel, would have entered without objection. Well, that has not been the history in these cases. Instead of those simple, straightforward orders being entered by the court, the orders file a motion to strike, 9 pages long, a motion for an order to show cause, 6 pages long, objections to entry of proposed order, 8 pages, and then a week or so later, an affidavit of factual observations, 5 pages. The orders in violation of the court rules then failed to follow the court rules by failing to serve those documents on me as the township's counsel of record. The orders in violation of the court rules to file with the court or serve me with a proposed order that they believe complies with the court's rulings on December 3rd, 2025. And they failed to follow the court rules to schedule a hearing and file a notice of hearing regarding their motions. I think they belatedly, after the court scheduled the hearing on its own, did eventually file a notice of hearing.
I advised them that they hadn't filed a notice of hearing. And then they said, well, what do we need to do? And I'm not sure, but I think then they tried to remedy it.
It's been my experience that when a party fails to set motions for hearing, fails to file a notice of hearing, and fails to file an alternative proposed order to the order they're objecting to, the court would not set a hearing date to the multiple, due to the multiple court violations. However, that is not the case in these cases. The history in these cases is that no matter what the orders file, no matter how many court rules are violated, the court sets hearings and Colon Township is required to defend. In addition to the above, the Yoder's motion to strike includes an alleged quote from Tiedemann v. Tiedemann, 400 Mich, 571, 1971 to support their motion. The quote, and it is a quote in their motion to strike, does not exist in the Tiedemann case, and the subject of the quote isn't even a holding in the Tiedemann case. In short, the Yoders either intentionally or through gross negligence attempted to mislead this court. The Yoder's motion to strike includes an alleged quote from a case they captioned In Re Estate of Temple Marital Trust, 278 Mishap 122, 2008 to support their motion. This case, the case with the site of 278 Mishap 122 is actually captioned Temple v. Temple, and the quote in the Yoder's motion does not exist in the case, and the subject of the quote is not even a holding in the Temple case. The Yoder's motion to strike contains an alleged quote from an alleged case captioned Palazzolo versus Gorsica with an alleged site of 200 Mishap 27, page 271, 1993 case. I could not even find that case by searching the names or the site. In short, the Yoders and those persons assisting them believe that when this court holds a hearing on a motion and makes the rulings on that motion, the order entered by the court in regards to the hearing must mirror the transcript of the hearing word for word. I refer the court to page 7 of the Yoder's motion to strike, where one of their relief for request states, direct plaintiff's counsel to submit a corrected order that mirrors the transcript word for word. As the court is aware, there is no court rule or statute that requires this, and to my knowledge, there is no Michigan court that would require this. If this were the case, then a transcript would be prepared after every hearing, and the judge presiding over the hearing would simply sign the transcript. After I filed and noticed for hearing my motion for sanctions, The orders filed an objection in response to request for sanctions, claiming there is no basis for sanctions. MCR 1.109E states the signature of a person filing a document, whether or not represented by an attorney, constitutes a certification by the signer that, to the best of his knowledge, information, and belief, formed after reasonable inquiry, the document is well grounded in fact and is warranted by existing law or a good faith argument for the extension, modification, or reversal of existing law. I'm going to go out on a limb and say, I don't think the Yoders or whoever prepared these documents on their behalf ever read the cases they were citing. If they did, they have committed intentional fraud on this court. On behalf of Colon Township and its taxpayers, I'm requesting that this court enter the two orders I submitted that accurately reflect the court's rulings on December 3rd, 2025, and grant the township's motion for sanctions, ordering that the Yoders pay additional costs and attorney's fees to Colon Township in the total amount of $1,624.68. which is the actual cost that Colon Township and its taxpayers have incurred in these matters since December 3rd, 2026. I would propose that that amount of $1,624.68 be divided between each case, since the motions were duplicated in each case. That half amount would be $812.34 in each case. Thank you.
All right. Mr. and Mrs. Yoder, the two orders that were presented, as Mr. Thornton stated, are brief, concise, and consistent with what the court ordered on December 3rd. They're asking for sanctions. We cited the rule. The person signing, for one thing, you're never very good on the procedural stuff. Getting notices, filing notices, getting dates, serving the other party. And he objects to my setting these things without you doing it right. Judge Stutzman might have just bounced it, but I wanted to get it to the next step, which is where we are now. But I would like to, at some point, have closure to this. You do have a right to appeal this. This is a circuit court case, so the appeal would be to the Michigan Court of Appeals. In a district court case, the appeal is to circuit court. This is a circuit court case, and the next level of appeal would be the Court of Appeals, and those procedural rules can be very difficult. So you filed your pleading stating your position. Mr. Thornton filed his responsive brief stating his. He's asked for sanctions, saying that you filed false pleadings. There's no merit to the pleadings that you did file, opposing these orders, which in my view are consistent with what I ordered on the record. So he's asked me to order you to pay $1,624. And 68 cents divided between each case. You did file a document called objection to sanctions. Let me take a look at that. Sanctions are not warranted under 1.109E, as he cited. Defendants were expressly authorized to file their motions and objections. Plaintiff does not deny the or factual issue accuracy of the proposed order. Yes, they do. The plaintiff does deny the accuracy of your contention that the order was not correct. Alleged citation errors do not support sanctions. Whoever's filing these pleadings, if they were an attorney, they could be subject to sanction from the Bar Grievance Commission. Now, these people aren't attorneys. There's not a crime. There are sanctions that can be done for practicing while without a license, but so you filed your responsive brief with your assistance. And is there anything else you'd wish to say regarding?
I guess our motions basically speak for themselves,
They do, they're
and I
written.
object to what he just got done saying, and I would like to have the objection noted for the record.
It is.
I say the order that he filed was very misleading. And the reason I say that is it doesn't have to mirror exactly what the court said, but I have the court transcripts for that day. And if you add or delete a couple of words, it will change the meaning of the whole thing. And that's why I say the order is misleading.
Well, here's what it ordered in each case. The defendant's motion identified above are denied in their entirety. And I denied all your motions. The order following hearing held on December 15th and entered November 5th shall stand as ordered. That's what I ordered. The restitution ordered in paragraph 1 of the order following the hearing on 10/15 shall be paid on or before January 2nd. No additional costs are ordered. That's what I ordered. There's nothing untoward or misleading about those. Defendant's motions identified or denied in their entirety. The defendant's order, the court's order held on October 15th, entered November 5th, shall stand as ordered. I'm going to sign the order in each case. Today is the 23rd of January. In file 25040CZ. Again, restitution ordered in that case shall be paid on or before January 2nd. That's not plausible. I'll make it due by 21 days from today. Today is the 23rd of February.
And Lance said that they couldn't even find that one case
Yes,
that we had listed. Well, I guess that's amazing that an attorney can't find it, but a dumb Amishman can find it.
that case would be
Right there it is.
Palazzolo versus Corsica.
To the best of my knowledge, I did not file anything that did not match with the paperwork.
Yes, that's to the best of your knowledge. Somebody's leading you down the pea path by doing bad lawyering.
But I guess the court order that I got had more writing in it than what you just read. I was gonna bring that order along and I didn't, I forgot it.
These are the two proposed orders that were objected to. Is that correct, Mr.
Well, the
Thorne?
court order that I got, it's got more writing in it than that.
I can state for the record, the order I sent to them under the notice of presentment was the exact same orders that were submitted to this court.
And it says more than what he just read.
Well, the ones I'm about to enter say exactly what I said.
And I guess if you look up sanctions and the rules and regulations for sanctions, sanctions require filings not grounded in fact or law. These filings are expressly authorized by the Michigan court rules.
There is no Palazzolo versus Corsica under that citation. David Corsica was the Oakland County prosecutor at that time, was a friend of mine.
And there was one other one. Show cause motion cites MCR 2.114E, which is a court rule that has been deleted since 2018. I guess I read that one, I checked in on that one, the rule was moved to MCR 1.109 effective 9/1/2018 and is still in effect under that rule.
Defendants' motions objecting to the entry of the order are briefed and preserved, and their objections are preserved. Those motions are denied, and the order shall enter as ordered by the court on December 3rd. The motion for sanctions is granted. The court will apply $812.34 per case. The others are due by February 21st. Those are also due by February 21st.
Your Honor,
Yes,
in order to try to avoid this whole situation again, I've drafted and prepared orders that you could look at right now if you wish to.
yes, I would.
That
Thank you.
would prevent me from having to submit it under the 7-day rule, objections and another hearing.
You have a right to appeal this. You have moved your birthing center, as far as I can tell, from that location. There is a need or demand or for your service. Just couldn't do it there.
Those are identical orders, Your Honor.
All right, let's review it. Did you give them a copy?
I didn't.
Do you have one for them?
I don't.
Or would you make copies for the defendants? How long while we enter them? I'm just trying to get the orders entered and finalized. If you wish to appeal it, you have that right. The appeal, as I said, would be to the Court of Appeals. The effects of the orders have mostly been accomplished. So we'll see where this goes. So these will be final orders that you can use to appeal my ruling. And I know you disagree with it. That's your right. The other stuff is just static. The orders are brief, they're straightforward. I believe they comply with what I ordered. I'm not sure what you're referring to as change a word here or there. Those orders are quite brief.
Well, like I said, the one that I've got had something in with motion with fraud was denied. I forget what all it was, but there was a lot more stuff than just what you read.
Defendant's motion to strike proposed order, and these are parallel. One is in 25040 CZ, one is in 25533 CZ. Paragraph 1, the defendant's motion to strike the proposed order of December 4th filed with the court on December 10th is denied. Defendant's motion for order to show cause filed with the court on December 10th is denied. Defendant's objection to entry of proposed order filed with the court on December 10th has been found to have been filed by the defendant without legitimate basis for filing an objection. Plaintiff's motion for sanctions dated January 12th is granted on the basis that the defendant's motions and objections were signed in violation of MCR 1.109E. Shall pay to the plaintiff. They've got 30 days in here and I'll leave it. $812.34 in each file.
What was the amount to put in there?
$812.34. If you double it, it's $1,624.68. That order is signed in file 25040 and in 25533 CZ. I hope this brings closure to the circuit court. Activity in this file. If it goes to the Court of Appeals, that's outside my province. They can review it. All of these issues have been preserved by your pleadings. So there are 4 orders entered today. They're the original order following the hearing that was submitted under 7-day rule that you objected to in file 25040 and 25533. Then I filed 2 additional orders, again in each file following this hearing. So you owe the restitution in the original case by December 15th, and you owe an additional $1,624.68. If you object to it, appeal it to the Court of Appeals. They have jurisdiction to overturn my ruling. They may view the matter differently than I did, but any further pleadings in this court could be met by further financial sanctions. All right. We'll get you copies of each of those orders. And we'll go take these up and file them with the clerk. And we'll get copies right now for the orders while they're here. All right, Mr. Thornton, thank you for the original orders and thank you for preparing those additional orders for today.
You're welcome.
All right, we'll be in recess. I hope this concludes this matter. Everybody needs to go to the next.